You know, when you look at a check or a promissory note, it seems pretty simple, right? Just a promise to pay some money. But behind that single piece of paper, there's actually a whole web of legal roles and responsibilities. So today, we're going to untangle that web. We'll break down who all the parties are, and this is the important part, who is legally capable of making that promise and actually being held to it.
So that's the real question, isn't it? When a payment gets refused or something goes wrong, who's on the hook? Who actually has to pay up? Getting this is absolutely key to understanding how these financial instruments actually work in the real world. All right, let's dive in.
Here's our game plan. First, we'll meet all the key players. Then we'll see how their responsibilities can literally change mid-game. After that, we'll get into the fundamental legal idea of capacity, see what happens when it's limited, and finally, we'll check out some special cases you might run into.
Okay, so before we can understand the drama, we have to know who's on stage. In the world of negotiable instruments, every single party has a very specific job to do. Let's meet the cast.
First up, you've got the drawer. This is the person who kicks the whole thing off. Think of them as the author of the promise. They're the one who pulls out the checkbook, writes the check, and signs their name, bringing the instrument into existence. Next, we have the drawee. So the drawer gives the order, and the drawee is the one who's supposed to follow it. The most common example, your bank. When you write a check, your bank is the drawee. They're the ones being ordered to pay the money from your account. This one's pretty straightforward. The payee is simply the person or company named on the check to get the money. You know, pay to the order of, whoever that is, that's your payee. They're the original intended recipient of the funds. Now here's where it gets a little more interesting. The holder might be the same person as the payee, but not always. The holder is whoever is currently legally holding the instrument and has the right to get paid. They're the one who can actually walk into the bank and cash it. And this right here is how the payee and the holder can become two different people. If you get a check and you sign the back of it to give it to your friend, you just became the endorser. Your friend is now the endorsee, and they've become the new holder. That ability to transfer it is literally what makes the instrument negotiable. All right, let's move on because this is where the plot really thickens. What's so fascinating here is that a person's legal responsibility isn't set in stone. It's not static. Depending on the actions taken, their role and how much trouble they're in if things go south can completely flip. Just look at this. This shows a massive shift. At first, the drawer, the person who wrote the check, is what we call the principal debtor. They're on the front line, primarily responsible. But once the drawee, let's say the bank, officially accepts that check, the drawer's role does a 180. They become a surety, which is basically a guarantor. Now, they're only secondarily liable. They only have to pay up if the bank fails to do its job. And hey, this isn't just some abstract theory from a textbook. This is settled law. These legal notes you see here point to a major case, Dalsuk versus Motilal. That case is what cemented this very principle into law. The court's ruling was clear. Once the drawee accepts the instrument, they step into the shoes of the principal debtor. The primary burden to pay officially moves to them. Okay, this brings us right to the heart of the entire discussion, because for any of these promises or responsibilities to mean a thing, the person making them has to have the legal capacity to enter into a contract in the first place. This is the ultimate test. So, here's the bottom line. Your ability to be held liable on a check is directly linked to your general ability to make any other binding contract. If you can legally sign a lease or a loan agreement, you can be legally held to the promise you make on a negotiable instrument. Simple as that. And, of course, the opposite is also true, and this is so important. If a party does not have legal competence, if the law says they are incompetent for whatever reason, then the contract is considered void, specifically against them. You can't force them to pay. Well, that raises a really fascinating question, doesn't it? If one person in that whole chain of possession, say the original person who wrote the check or someone who endorsed it, lacks legal capacity, does the whole thing just crumble? Is that check now just a useless piece of paper for everybody else involved? To answer that, let's zoom in on the most common example of limited capacity that we see, minors. The law has some very specific rules here, and they create some pretty interesting outcomes. The starting point for this is absolute. The law couldn't be clearer. A contract made by a minor isn't just something they can cancel later. No, it is considered wholly void from the instant it's created. This is a massive legal shield for anyone under the legal age. So how does this all play out in the real world? Well, the minor is completely protected. You cannot sue them on the instrument, even if they lied about their age. But, and this is the part that surprises people, the instrument itself is not worthless. A minor can still receive a check and be a payee. And if that minor endorses the check over to an adult, that transfer is totally valid. All the other competent adult parties in the chain are still on the hook. The minor's involvement doesn't let anyone else off the hook. And again, we've got case law to prove it. The notes on screen mention a case called Gray versus Cooper, which confirmed this exact idea. The court basically said that the other adults on the instrument can't just point to the minor and say, well, they're underage, so I don't have to pay. Nope, the minor's involvement does not give anyone else a free pass. All right, for our last section, let's see how all these principles of capacity and liability work when we're dealing with more complex entities, things like corporations, family businesses, or people representing an estate. Whoa, okay, before we go any further, let's just pause on this slide because this is a huge, huge warning for everyone. If you are ever signing a document as an agent for your company or for an estate or on behalf of anyone else, you absolutely must make it crystal clear that you are signing in that role. If you just sign your name, you could be held personally liable for the whole amount. That is a very expensive mistake to make. This table is a great little cheat sheet. For a corporation, liability depends on what its own founding documents, its charter, says it can do. For a Hindu undivided family or an HUF, the head of the family, the Karta, can make binding agreements for the whole family, but usually only for family-related business. And as we just talked about, a legal representative for an estate has to be so careful to limit their liability or they'll be paying out of their own pocket. And this slide really drives that point home. See the sample language here? Promise to pay, out of the assets of the deceased? Without those magic words, without that explicit limitation, you could end up like the executors in the case of Hirji Boy versus Ratanbai, who were held personally responsible. The exact wording here is everything. So we'll end with this thought. A negotiable instrument is really like a chain. Every person who signs or possesses it is another link. The strength of that entire chain depends on the legal capacity and the clearly defined role of every single link. So the question you always have to ask yourself when you look at one of these is, how strong is every single link?